This conference is now being recorded.
Welcome to the New York State Association of School Business Officials webinar. Today's webinar is the Benefits Information from Experts, Part 2. Your host for today is Donna Clement, Director of Professional Development. Operator assistance is available at any time during this conference by pressing #. Following the presentation, there will be a question and answer session. You may send chat questions at any time during the presentation using the chat window indicated by a speech bubble icon located to the right of the presentation. Please address chat questions to the Q&A group using the drop-down list located at the bottom of the chat window. I will now turn the call over to our host, Donna. You may begin.
Thank you, Leo, and welcome everyone to Benefits Administration Part 2. And we certainly do have some experts for you today. And Marcia Jones from Salamanca will be introducing them and facilitating the program. I do encourage you that as you're listening to the information, if a question comes to mind, email it to us, and we will be glad to answer it then or save it for the Q&A group. If you'd like more information on something, make sure you let us know. This webinar is for you, and we want to make sure you get the information you're looking for. And now I'll turn it over to Marcia, who has recruited all of these excellent presenters with good information, and we're glad to have Marcia as part of our team.
Thank you, Donna, and good afternoon to everybody, and welcome to Part 2 of the Benefits Administration webinar. These will be completely different topics that we will be discussing today than compared to what was discussed last week. We do have unemployment insurance, which will be covered. I will be presenting that information. However, an expert is the one who provided me that information. Her name is Melissa Willie. She works for the Department of Labor, but because of her hearing schedule, she's not able to make the webinar today. We do have our health insurance, who's presented by Beth Miller of Excellus Blue Cross Blue Shield, and I can tell you she tailored her presentation to the questions that people were submitting through the blog. So I hope everybody will get their questions answered. And then our 403B plans, as well as other tax-sheltered annuity products, will be presented by Ellie Louder, who's an independent consultant, and she works with AXA Equitable and is coming through to us today with the support of AXA Equitable. Just a couple housekeeping reminders. There will be time allocated at the end of this presentation for questions. However, if you would like to type them into the chat menu, we will try to keep track of those, but there will be 15 minutes set aside to ask questions, so I encourage asking any questions that don't get answered as we go through this webinar. Another reminder is between today and the end of the month, please make sure you go on the New York State Association of School Business Officials website and share one of the best practices from your district. The best way to learn how to do things is not reinvent the wheel. Why not share what we all do best? So please go ahead and add that to the blog. Any information or details regarding any of the assignments can be found on the website. In addition, the other assignment to go with this webinar today is to email me of the changes that you would like to implement in your district that you have learned through this webinar, either Part 1 or Part 2. We're going to go ahead and move right on to the first topic today, and that is unemployment insurance. So what is unemployment insurance? The New York State Insurance Program, which is administered by the State Labor Department, provides immediate, short-term protection for people who are out of work through no fault of their own, and it is financed by employers through a tax on their payrolls. There are some reporting and records requirements when it comes to New York State unemployment insurance. The first thing is all employers must report newly hired employees within 20 days of their hiring date. And just to determine what their hiring date is, it is the first day that they are actually working for you. So it is not the day they're appointed by the Board of Education, but it's the first day they're actually providing services for your district. In addition, there's quarterly reporting that's required on the New York State 45 or the New York State 45 ATT form, and I have listed the due dates. for the reporting. So every quarter, following the end of the quarter, there will be the reporting requirements sent into that form. Just like a lot of things that happen in our world, we're subject to audits. And the Department of Labor does conduct audits. They look for the accuracy of the coverage of the workers, the reporting of the wages and payments of taxes that are due. So to be prepared for any of those audits, records must be maintained for at least the current year and 3 preceding years and be available for inspection. Records need to have the name of the employee or former employee, the Social Security number, and then for each payroll period, the beginning and ending dates of that payroll, the days that each employee worked and earnings were made, and then all other payments, maybe a vacation, sick time, bonuses, or if you are doing dismissal pay, those all have to be included. So there's 2 different options when it comes to paying unemployment insurance that school districts have. The first option is to pay it through quarterly taxes. If you're choosing that option, unemployment taxes based on the first $8,500 of pay each calendar year per employee. Then there's different rates that come into effect. Your normal tax rate ranges between 0 and 8.9%, and that is set annually. Then for periods where the general account, the balance is too low, they can do a subsidiary tax, which ranges from 0 to 9.25%. And besides the account balance of the general account, it also includes your individual and experience, so each individual district's experience. And then if you choose to go that route, you do have a required contribution to the Reemployment Service Fund of 0.075%. Another option that's available besides paying that through your quarterly taxes is only available for not-for-profits, government entities, and Indian tribes, and this is the reimbursement option, where you would actually be billed quarterly and reimbursed in New York State for the benefits they've paid to your former employees. If you are choosing this option, you are not required to contribute to the Reemployment Service Fund. As far as the benefits, to qualify for benefits, claimants must be out of work through no fault of their own, must demonstrate recent substantial attachment to the labor market, must be ready, willing, and able to work, and must be seeking suitable employment. The determination for the benefits amount and rate is primarily determined based on the wages that are reported on those quarterly reporting forms. And right now, the New York max is $405 a week, and then, of course, Obama added the additional $25. A person can apply online or over the phone for benefits, and the Department of Labor will determine eligibility, and a notification of that determination will be sent to the employer. Now comes the hearing process, and a lot of this presentation is based on this because with the high rates of unemployment, there's a good chance that a lot of us will be going through this hearing process. As soon as you get that notification sent that one of your former employees has been determined eligible for benefits, you have 30 days to be able to request a hearing, and that's a very important date. A hearing can be requested by either the former employer or the former employee, and it must be requested in writing. And that hearing will take place before an administrative law judge. It's really a very informal hearing, and if for some reason you are requesting a hearing because you believe that the employee should not be eligible for benefits because they were fired for misconduct, it's very important to put that reason in your letter when you are requesting that initial hearing. So how does the process work? You will be receiving a hearing notice, and on that hearing notice, it'll list all the parties for the hearing, the issues that are going to be heard, and then the instructions on what the parties need to produce for the hearing. Another important aspect is this notice will tell you whether or not the hearing is either by phone or whether it will be in person. If it will be conducted by phone, all the documents you need will be mailed to you, but it's very important to make sure that the phone number that's listed on the form is correct, and to make sure if that phone number is not correct, to let the judge know what number they can get a hold of you when they call you to conduct that hearing. If it is going to be in person, a best bet is to arrive at least 15 minutes early so that you can review that file that you would have been sent had it been over the phone. So what is the hearing process? What is the hearing? It's really an informal recorded hearing with the judge, the employer, the claimant, or the claimant's representative, along with any witnesses that either party can bring. That is either done over the phone or in person. The judge will provide opening statements in which it will advise all the parties on how the hearing will be conducted and their rights. Either the judge or a hearing rep can make an additional statement about the determination. All parties have the right to testify, to ask questions, to produce witnesses, and to provide evidence to support their case. Some of the important things to know about when you go into a hearing. First-hand knowledge. All parties should produce the actual witnesses who saw or heard the final incident. The appeal board has consistently ruled that first-hand testimony prevails over hearsay evidence. When you go to the hearing, please make sure that you have all of your required documents, the dates of the employment, the pay rate, the title of the person, the claimant's title, all the information that pertains to the issue before the judge. It is important to supply all the documentation at the hearing, because an appeal cannot solely be based on the need to provide more documentation. So if you don't provide it at the hearing, it's almost as if it doesn't exist. So Melissa wanted to stress to everybody on this call, please bring every single piece of documentation you might think you need to that hearing, because if something comes up 2 weeks from now, chances are you will not be granted an appeal just to enter in new documentation. When you attend the hearing, it's very important that you actually attend, because it is your only opportunity to provide sworn testimony, examine documents, and to cross-examine the testimony given by your former employee. If you cannot attend the hearing or your witness cannot attend, notify the judge's office as soon as possible, because if the hearing was requested by you, chances are you can reschedule. If the hearing was requested by the claimant, it'll probably still go on, and then you can try to reopen that hearing at a later date. If new testimony that you're not aware of is given at the hearing, you can always ask the judge for time to refute that testimony. It's always fine to bring a list of questions that you want to ask with you. And then you do have the opportunity, all parties do, for closing statements at the end of the hearing. Decisions are usually rendered within 1 to 2 weeks of the hearing, and if any party disagrees with the decision, you have 20 days from the date of that decision to file an appeal. As far as conduct, basic things: don't remain calm and respectful to all parties. And as far as addressing the judge, it's okay to refer to the judge by just judge, or you can refer to them by judge and their last name. There is a great website which is listed here for hearing preparation. So if you want to get into more detail on what you should have prepared in case you do need to take a hearing either by telephone or in person, I suggest that you go to that website and review the tab called Hearing Preparation. Now I have some things that we're going to come across in school districts, which is voluntarily quit or misconduct. And she gave me some good definitions of the difference between the two. If someone voluntarily quits, they left their job at their own free will, And this also includes a situation of when someone is on a lack of work with a definite date to return given to them when they are laid off, and the person does not report to work as scheduled. The claimant must provide they had good cause to quit. Misconduct, however, is when an employee is involuntarily separated due to a volatile act or omission that is detrimental to the employer's interests. Sometimes it does include off-the-job actions. Employers need to prove misconduct occurred, what rule was violated, and were they aware of that rule and any warnings that employee would have had. And they need to pinpoint the final specific accident. Poor performance, mere inefficiency, good faith errors in judgment are not considered misconduct. Resignation in lieu of termination. In the past, the appeal board viewed resignations in lieu of termination as an act of quitting, but now that is not always the case. And some of the reasons that were given is some teachers that might be denied tenure and decide to resign. The board has been providing those teachers benefits because it is such a negative mark against that teacher's record that the board has been providing unemployment benefits. And misconduct is something that is on the employer must prove at the hearing. So chances are that that initial notification that will be sent would provide benefits to that employee, and it would be through that hearing process that you as an employer would need to prove misconduct to therefore not be eligible for benefits. Reasonable assurance, something that districts that have especially substitute teachers, other forms of substitutes, should be aware of this. What it does is provides a means to not make it eligible for people, substitute teachers, for example, to collect unemployment, whether during a vacation, a holiday break, or during the summer between one school year and the next. It is always effective the Monday after an employee is notified that they will be employed by the district the next year. So the best way to do that is to send out letters to all your substitutes saying that, you know, you are going to add them to your substitute list for the following school year, unless they decide they don't want to be added, in which they would let you know. Some employees may have reasonable insurance for the entire summer recess if they are notified in June. For others, it may not have reasonable assurance until July or August, depending on when the employer notifies the employee about working for them. For periods of vacation break, reasonable assurance exists when a substitute has worked 1 day in the 7 days prior to the break, be placed on a priority list for the employment in the week following the break, and only that list is used to call in substitutes for the week immediately following the break. The section of law that deals with reasonable assurance is very complicated. Just because you send a letter out to your substitute, but that substitute might work for the neighbors or the school district down the road, they might not send out that same reasonable assurance letter, you might end up paying benefits to that substitute because of that. If you have questions on this specific topic, please call the numbers that I'm going to give to you later in this presentation, because even experts have to look at every individual case at the Department of Labor to determine whether or not you are fully covered and you did provide reasonable assurance. So any questions regarding that, I suggest to please call. You can call right to the first number that's on this screen for unemployment insurance questions. If you have questions on liability or determination, there's a number provided there. If you feel that there's fraud, there's a fraud contact number, and then that same website if you have any want to do any further research into the topic. And that is all I have for unemployment insurance. So I am going to be passing the presentation on to Beth Miller, who will be covering health insurance, and like I said, design this presentation through some of the questions that some of the participants have been submitting through the blog. So thank you for those questions. And go ahead, Beth.
Great. Thank you, Marcia. My name is Beth Miller, and I've been an employee of Excellus Blue Cross Blue Shield for 20 years now. And I actually handle school district TST BOCES. So last week we actually had a board meeting, and we had one of our representatives from our Rochester region out to go over this topic, and it obviously is a very hot topic out there. Although mandates are not new to us, this mandate, dependent to 29, actually has a twist to it. So for the agenda that I kind of put together is we'll go over the law and what the intent of the law was, and then what it means and how is it going to be processed through the insurance companies. And there are still a lot of questions that are outstanding. Last week when we were together with our lawyers, they had indicated that they have sent back several questions, including not only us, but other carriers that had questions surrounding the law and are still waiting for answers. So this law actually could be rewritten or changed in some form going forward based on all of the questions submitted to the insurance department. You can go ahead. So let's take a look at that. The bill was actually signed on July 29th, just before the session was let out for summer break. So Governor Patterson signed the law effective September 1st. Now, if you read the next bullet, it says applied to contracts issued, renewed, modified, or altered, or amended on or after that date. So if you are have a renewal date of July 1st, the law was effective September 9th, you do not have to make it available until next renewal. If you modify your contract, let's just say for January 1st, then you have an opportunity to make that available. You may be having people come to you directly saying, well, I want it effective, it says it's effective July or September 1st. The law is a must make available. You can go ahead. Right now, a lot of the contracts are covering dependents to 23, full-time college students to 23, or full-time college students to 25. Typical coverage covers dependents to age 19. The law specifically states unmarried children for the subscriber through age 19 or age 29 up to their 30th birthday. They cannot be insured anywhere else, and they cannot be eligible for health benefits. So if they are 20 and they're working at Dunkin' Donuts that offers them insurance, but they choose not to take it, they are not eligible for this. They have to live, work, and reside in New York State, and they cannot be covered under Medicare. So those portions of the law are pretty clear. You can go through. However, coverage can be obtained. A group may purchase this coverage and offer it as a rider. And let me explain this to you. There are two options to look at this law. One, it's an extension of coverage that would almost be termed as Cobra. So looking at that, you could say, okay, this person is past age 19. Now they would be covered under this new law. We'd list them as a single, and they would pay a single rate, whatever the single coverage rate is that the group is paying. Or the group has an option to add it as a rider. Now, a rider to a family policy right now is being reviewed by New York State Insurance. We have written a rider to add to group coverages that would cover a dependent, unmarried, not going to school, living within New York State, meeting all those other requirements. And we've had our underwriters review it for a rate, and it is at New York State Insurance. To add that, it's just like adding a rider. So if you were adding immunizations or an adult routine physical, there's an actual charge for that additional benefit. Two ways to cover it. Look at the person as a sole person. They would be paying a full rate of a single, or add the rider upon renewal. So two ways to cover that, but however, it's also looking at the exposure to the group. And then there's other questions that fall out from that. The intent of the law signed by Governor Patterson was to make sure that this was not going to impact the groups in any way, shape, or form. However, it does open the exposure of claim risk, but they are responsible for the premium differential. So whether you charge a full premium as an individual or add the rider at, $5, $10 or whatever it would cost to add the rider to the entire group, then it would be opening your exposure as more participants would take the coverage if it was $10 or $20 more a month versus adding one individual at a $500 individual cost per month. So things that you want to look at if you are in a situation where you have the time and you don't have to add them right away September 1st. You can go ahead. This is also a review within Excellus Blue Cross internally that we're looking at all membership aspects and operational aspects of the new law as to special open enrollment. We did have an interpretation from our lawyers indicating the 12-month election period is when the law was available. So if somebody was a full-time college student and left and took the summer off and decided not to go back, but they're 24 years old and now they would be eligible for this benefit based on the law, they have a 12-month enrollment period to make that election. This is another question that came up during our presentation on last Friday. What would be the intent of people moving on and off when they needed coverage? So those are other questions that are still being addressed. I'm all set, Marcia. The other thing that you'll see is other questions that came through where premiums must be billed no more than a month. 30-day grace period applies. What happens if they miss that? Are they off the policy, or do you have to extend coverage past the 30 days? That's another question that's out there. One question that we know is correct is the fact that you cannot add the 2% additional administration fee that you can with the Cobra billing. So the billing is still being determined at this point, whether it's going to be billed from the insurance carrier to the member directly or to the group who collects the premium. The last day for which a premium is paid, the child no longer qualifies once they reach the age 30, so that would be a termination point. We are still getting clarification regarding Cobra from that extent. This also pertains to our membership that is still being worked at. They are looking at how they're going to notify the member once they are eligible to receive this and the special election. The employer does not have obligations under this law, but is required to offer this, is not required to offer this as a benefit. So it's must make available. This is where you want to start to look at your own plan, how your group is funded. If you're a self-funded group, you do not have to offer the mandated coverage. With mandates, we've been through a lot of mandates in the last few years. Actually, from 1997 to 2007, there were 30 different mandates passed. Most of them that do not apply to self-funded groups. However, if the group agrees to administer this, the plan, then the group is responsible for the employee's claims. All claims are tied back to the group's experience. Minimum premium groups, premium credit, they are subject to the mandate. They are fully insured contracts, and again, handled in a similar fashion as Cobra, not allowing the 2% on administration, but moving them over to a single policy or the option of adding the actual rider once we have a rate available. National accounts who are headquartered in New York State but have employees and dependents that live outside. Right now, our interpretation from our lawyers, Hinman and Straub, is they actually have to live in New York State, but the department is actually reviewing that for more clarification. So as you can see, this law, there's several outstanding questions regarding that, and our lawyers actually think there's going to be some revisions to what was initially put out on the website. because of the questions being inundated. So please stay tuned on that. Cobra Extension, the 36 months. Again, Governor Patterson's ideas to provide coverage longer as some of the subsidiary government programs are going to start drying up. You'll see Family Health Plus, Child Health Plus, all of those programs, you're going to see the income levels rise, and you're going to see that cut back. So they're actually moving people back to private insurance to have them stay with that longer. Again, this law is not complicated or as complicated as the last Dependent 29. Again, it was signed into law the 29th of July, just before recess, their vacation. It took effect July 1st. It applies to all contracts that renew or modify, alter or amend it on or after that date. If a person is with Cobra, but it expired in June, they're not eligible. But if they're in the middle of their Cobra, it would just extend it from the 18 months on from 36 or out to 36 months. So 19 to 36, they would get that extension. So who is covered? Anyone who is currently on Cobra. We have actually gone into our systems and calculated that extension from 19 months out to 36 months and put dates on that. It doesn't require action. We have already taken the steps. However, you may want to check with your individual carriers to see exactly how that date is put out there and that it is put out there within the system. Let's see, qualified members, who is eligible, Cobra expired after the July 1 effective date, email escalated questions. Right now we're getting a lot of questions regarding that. Membership is handling those on a one-to-one basis, so you may want to check with your individual carriers exactly how that's being processed. This kind of brought us back to where we started, since this law actually was signed in such a short time ago, trying to look at what we've done to prepare our customers and our groups with knowledge. We've updated our members through our website, our employers, our brokers that we work with, and we do have information right on our customer service. We right now have a target date at Excelis that we have to notify members that this is available. The law is indicated to the carriers that they have to make this available. It does not indicate what the letter has to say, so we are still working through the actual language of the letter and looking for pointers from New York State. And then internally, operations, the operationalize of this law has been challenging for all carriers. This has been the twist that we've had mandates put into place before. We've had them retroed back to January after you're sitting in February. Everyone gets this law effective January 1st and it's February 5th. We are able to overcome those obstacles. However, this law still has a lot of questions out there, and operationally we are working through to make sure that we meet the requirements of the law. These are some of our internal talkings regarding how we're handling it internally. I would check with your individual carriers to see when their notification is going out. If you're able to get a copy of that prior, just so you're aware of it. Please check our website if you are an Excelis Blue Cross Blue Shield group or member. There is information regarding how we are updating our systems, our notices to members, and what the law is, and the questions that are outstanding that we're still waiting for. So, lots of questions.
Thank you, Beth. I think we're going to move right on to Ellie's presentation. And for all the participants, please make sure you're thinking of questions. So once Ellie is complete, there will be an opportunity for those to be asked either through chat or through the phone.
All right. Thank you so much, Donna. And Marcia, I really do want to thank you for providing some insights for me as I put together this presentation so that it would be meaningful for you. Hopefully this, the next several slides, which I'll run through rather quickly, will help you understand not only the benefits, but the responsibilities, the new responsibilities of your 403B plans. This is just a brief bit of information on me. You can read it at your leisure. I won't waste a lot of time on it. Suffice it to say that I do have a lot of expertise in this area, and a special thanks to the AXA Equitable for making me available to you and for being a strategic partner of ASBO International as sponsor of the Eagle Awards. Moving on, we'll go right into the things. Oh, I'm sorry. I always have to say this, folks. I don't provide tax or legal advice. Moving on. We can go to the next slide. I want to talk, about the benefits. I know that the IRS regulations have created a mindset for us. I don't like these regulations any better than I suspect you do. But just a reminder that since 1961, when this came into existence, it has been a very real benefit both for you and your employees. We'll just touch on that. I also want to kind of respond to some issues about 403B and 457B plans. Sometimes the question arises, should you sponsor only one or both? We'll try to answer that. What the regulations did and did not do, just a few refreshers for you. The all-important universal availability requirement. And if you have something which is broken, some thoughts on how to fix it. And the importance also of maintaining oversight of your third-party plan administrator if you're using one, which I understand most people are. So first, how does it benefit you? Well, in terms of your employer relationships, it's very good for employee morale and retention. It's great for saving budget dollars if you use employer contributions. You can use it to retain hard-to-find specialty teachers as a benefit, superintendent benefits packages, early retirement incentives when your problem is potentially too many teachers at the high end of the scale and the need to replace them with lower-paid people, which is a big budget consideration, and also replacing more expensive unused leave pay. I think this employee morale and retention issue may be one of the biggest ones, and we'll kind of focus on that by saying this. Employees have come to rely upon this as a long-term benefit which they've become accustomed to. If for any reason something happened to interrupt that benefit, it could be regarded as a takeaway. So it's extremely important because historically you've sponsored these plans for so many years. In terms of employer contributions and why they might make sense for your situation, they're not subject to payroll taxes. That's an item that's a savings for both the employer and each impacted employee. Also, depending on contracts, employer contributions may not be subject to fringe benefit payments, so that the savings can be significant. And I have seen districts all over the country taking advantage of employer contributions. Now we come to how do 403B plans benefit your employees? Well, it's essential to be able to accumulate a pot of money for retirement needs beyond income needs. There's also widespread concern, folks, and I expect you know this, about the health of the state retirement system defined benefit plans. Most are fine, but some are underfunded, and so people begin to be concerned. Will my retirement income be impacted by the economic downturn? And if so, is there a way to supplement it? And this is that way. It also gives employees the growing interest, access to the growing interest to be able to accumulate their money in the 403B Roth option. More and more people are worried that taxes are going to go up in the future, right? And I think many of us believe that might have to be the case, where the 403B Roth option permits tax-free distributions if certain conditions are met. And then as we move to the next slide, it's also, it's important also that they own their accounts. Now, I've heard some people ask the question, since we have to deal with these final regulations and we're not totally ready or clear on how to do it, why don't we just terminate the 403B plan and replace it with a 457 plan? I think it's virtually impossible for you to terminate your 403B plan had that been under consideration by you, because in terms of termination, every asset in the plan has to be distributed, and in most cases, because they're held in individual accounts, you can't distribute without participant consent. So it becomes rather a moot point. Some people then want to think about, well, okay, should I have both plans? And there is something to be said for that, because if you have both plans, it permits a double deferral opportunity, which can be of interest to certain employees, depending on the affordability factor, meaning you can double up on your ability to save through salary reduction contributions, because there is no coordination of limits, which means that your compliance responsibilities are not exacerbated with having both, except that if your 457 and 403B plan both offer loans and hardship withdrawals, the hardship withdrawals and loans have to be coordinated, not only between the 403B and 457 plan, but I understand you may have a loan option in your state retirement system plan, so you want to be conscious of that. Loans especially are a single limit for all plans. Just a very quick look at the differences between 457 and 403B. Sometimes it's misunderstood. 403B plans have a 10% penalty tax for many withdrawals before age 59 and a half. For governmental 457 plans have no penalty tax. 403B plans permit access in service at age 59 and a half, and in governmental 457 plans, it's age 70 and a half. Considerable difference. In 403B, you can access funds if you have a hardship, which is has fairly liberal rules, including funding college education and the like. In 457, it has to be an unexpected emergency event, unforeseeable, the IRS loves to call it. You can also, in a 457 plan, however, distribute small accounts under $5,000 if certain conditions are met in service. In terms of employer contributions, the ability to make those contributions to solve potential issues outlined before, 403B is certainly the plan of choice because it has a $49,000 limit and there's no FICA tax. You can also make those contributions in 403B for up to 5 years after employees leave. I'm told fondly that it benefits the buyout of contracts sometimes. With 457, it's not terribly attractive because those are still treated as employee contributions, and FICA does apply, and you have a much smaller limit. Some additional differences very quickly. The investments in 403B are always limited to annuities or mutual funds. In the state deferred compensation system that you folks have access to, I am told that your limitations are mutual funds and exchange-traded funds, so there's a slight variance there. In terms of fiduciary issues, generally you're not a fiduciary for your 403B plan, and I'll elaborate later on that. But under most state trust laws, and you'll see that at the bottom of the screen, you may be a fiduciary for your 457 plan because those assets are required to be held in trust. 403B has the Roth option, 457 does not. So there may be reason to sponsor both plans to meet all goals for employees if you look at those differences. Now let's take a quick look at these pesky 403B regulations. Those extensive changes were effective on January 1, 2009, and suddenly you became responsible for all of the compliance responsibilities. However, the IRS did, in their infinite wisdom, or on the contrary, I don't think it was, permits you not to adopt your written plan until December 31, 2009. That's the drop-dead date. On the other hand, if you don't adopt it until late, you have to remember that when you do adopt it, during 2009, you have to have operated it in accordance with its terms. So you want to be careful if you didn't adopt your plan before 1/1/09 to check the operation of your plan and make sure that you match the features in your plan to the transactions that took place in 2009. Otherwise, you must file for correction with the Internal Revenue Service, and that's not a fun thing to do. What did the regulations not do? They didn't make you a fiduciary for your 403B plan. You are non-ERISA employers. You're totally exempt from ERISA. So the only other source of fiduciary responsibility would have to be governed under state statutes. And I have to say that in general, state statutes do not impose fiduciary obligations on 403B plans. You want to always be familiar with your own state statutes, but just as a general rule, they don't, because 403B assets are not held in trust. One of the things that employers often ask me as I visit with them around the country, and I do that a lot, is should we, because of these regulations, assume oversight of investment choices or performance or have an investment committee or what have you? And unless you want to be perceived as a fiduciary, the answer to that would be you might not want to do that. Before you do it, be sure and check with your legal counsel to see if they're comfortable and your board is comfortable with assuming that responsibility. One of the things that people worry about is, wow, if we make a mistake in the operation of our plan, is it going to disqualify our plan? I mean, that's a scary thought. In 403B, you are fortunate in that there are only 3 events that could disqualify your entire plan. The failure to adopt it, and I don't think any of you are not going to adopt your written plan. I suspect most of you already have. Or if you weren't eligible in the first place, and as public education employers, you're definitely eligible. It's the third one you want to watch, and I'm going to talk about this a little bit because it's such a hot button for the IRS. That would be failure to make your plan universally available to your employees. We want to explore that one, and as we go to the next slide, you want to remember that the general rule is that if any of your employees are permitted to make contributions to 403B through salary reduction contributions, then virtually all employees must be given that right. What you want to be very careful of, too, is that the regulations, the final regulations, specifically say that employees have to be given an effective opportunity to enroll or make changes. And they never tell us what they mean with their verbiage. So what does effective opportunity mean? Probably the easiest way to approach that would be to provide meaningful notices to your employees. And in terms of your administrative burden, not making it too great, as frequent opportunities as you can manage for them to enroll or make those changes. Probably you want to be careful, for example, of only permitting, online electronic enrollments, unless you're absolutely certain that every employee is both computer literate and has access to a computer to do this electronically. Otherwise, you must provide a paper alternative to avoid violating the effective opportunity. And in general, you can't have waiting periods or establish ages before people are eligible to participate. Now, what's the easiest way to comply? As we go to the next slide, the easiest way to comply, if you can do it, is permit all common law employees to participate. And notice this, if they will contribute $200 or more each year. The regs and the code clearly say that you can exclude any employee that will not contribute $200 or more, or that is not planning to contribute more than $200 a year. And the reasoning behind that is you may have trouble finding product vendors that will accept tiny amounts, right? You can get agreement from most of them that they will accept $200, but for the smaller amounts, probably not. It also eliminates some of the burden of having to permit all of your employees to participate in terms of administrative burden. So I would use that one. Do not exclude any classes of employees. This is the one the IRS gets hot after. If you're saying, well, we're excluding all substitute teachers, then they gleefully, and I probably shouldn't use that word, will find you in violation of the rules. So don't exclude by class. Be careful of that. Now, how can you avoid problems additionally? One of the exclusions you're permitted to have is certain part-time employees. I personally see that as being problematical, or it could be, because you're permitted to exclude employees if in the year of hire you don't expect them to work 1,000 hours, or in years after they don't actually work 1,000 hours. I worry about that one, because if you let any one employee in that actually worked less than that, then you had to have let all employees in to work less than that. So it's probably better to avoid the violations, to maybe avoid excluding based on hours. I can tell you quite simply that most really part-time employees aren't going to participate anyhow. So you're not increasing your burdens if you simply let all common law employees participate. An effective opportunity, I've already mentioned, don't have to dwell on it too much, but make sure that it is meaningful and effective. That would be permit enrollment or changes as often as you can, because that removes any doubt. Make sure that you've provided notification to your employees. And in order to make it meaningful, you should have alerted your employees, and it could be in that notification, of the list of your approved providers and how to get more information. In other words, telephone numbers, contact numbers, so that they can readily obtain information to enroll. The other thing I would kind of watch is that when the IRS comes in to audit, one of the things they're going to ask you is how you notified your employees. So you want to maintain records of how you've done that. Use a method of delivery that ensures that all employers are going to see it. You might want to use a variety of things, whether it be bulletin board notices, employee newsletter, what have you, to make sure that you can demonstrate to the IRS that you did this. And in the next slide, keeping proof, There isn't any need, folks, and I get this question now and then, and I think it's burdensome to think you have to do it. I don't think there's any need whatsoever to have every employee required to affirmatively acknowledge that they were notified. I've seen some say, well, you should have every employee sign a card saying we were notified and we chose not to participate. I think that's exceedingly unnecessary if you maintain careful records of the communications you used to notify your employees. And the first thing you can hand to the examiner are copies of what you did and the dates of the communications and so forth. So you can help defray your administrative burden by not requiring a signed card. Okay, how to comply. I think 77% of employers have reportedly hired TPAs. Some chose not to. But let's look at, if you have a TPA, just make sure they are managing the compliance transactions, because their management of the transactions does not remove your responsibility for compliance. The IRS is going to come to you. And yes, you can have service provider agreements in place, and you should, in which the TPAs take responsibility for errors that they make or omissions that they make. But so that you may be able to be reimbursed if the IRS finds you liable and it costs you money. But the ultimate responsibility is yours, and it cannot be delegated. So to me, oversight of your TPA is just so vital. And one of the reasons for that, as we look at the next slide, is that there have been widespread reports of systemic service issues. I helped put together an NTSAA Problem Resolution Summit, where we pulled in roughly 40 product vendors, and I think it was 30 TPAs all around the country gathered to work on resolving these issues on your behalf. ASBO was there, I'm so happy to tell you, and you can see a report of that summit at the NTSAA website. We also, on behalf of ASBO, the ASBO Retirement Plan Council posted a summary of that report on your 403B resources page at asbointernational.org. You might want to take a look at that. One of the nice things about this is it outlines solutions to the current service problems, and it defines the role employers will need to play. The ASBO member that was there represented you extremely well. You will be seeing some results from that. And on the next slide, you have 2 industry task forces that are currently working on standardized forms and procedures on your behalf and best practices educational materials to share with you, the providers, and the TPA so that everyone is on the same page. I think the results will make a difference, and I strongly recommend that you stay stay tuned. In fact, I was on one of the task force calls this morning getting a report on progress. So what is this all about? It's a partnership, folks. It's an important partnership. You're not on your own. I think that's so important for you to understand. The industry cares, the product providers care, and the TPAs care very much about making this run smoothly. You are the ones, you, in the second bullet point, that are in charge. And I think you need to employ a firm hand in whatever final decisions you make and that you've already made and that you will make going forward. Key here is always communicate your decisions, not only with your TPA, for those of you that have one, but with your product vendors, if you don't have it, whether you do or not have a TPA, so that the plan can be properly managed. The providers and the TPAs need to know what your rules and your requirements are in order to accommodate them. You must also be prepared to deselect. Deselect, folks, non-cooperative vendors. If you have providers out there that are unable or unwilling to do what needs to be done, you are in the driver's seat and you should consider deselecting those providers. Now, in terms of what's happening out there, 77% of school districts are using a TPA. The balance are partnering with the product vendors to self-administer. And the partnership in that is just so vital because the providers have to agree to cooperate with you and one another in providing compliance support. On average, providers selected around the country average 7 providers per district. Considerable downsizing has already taken place. Only 6% moved to a single vendor. And I think a lot of that, according to reports, is because employers did not want to be perceived as attempting to assume a fiduciary role. And there's also been some union resistance to single provider selections. So to share that with you. How do you select good product providers? Even though you've probably already been through the process, you want to be conscious of this going forward because what your program looks like today with the number of providers or the providers selected today may not be where you want to be next year or 5 years from now. You must appear to have used the selection process which the regulations require, really, that you work with providers that can agree to share information necessary for compliance. And really that needs to be in a format that meets your system's capabilities. Very few employers vetted based upon investment performance because they wanted to avoid any perception that they were recommending providers based upon their performance. By choosing based on compliance, you help employees understand the selection process as a necessary measure to protect the tax status of their accounts. And that's exactly what you're doing. And communicating that selection process to employees is a very simple thing to do. Finally, is it too late to fix it if there's something wrong? Absolutely not. You want to watch, the caution if you went to a single provider, certainly, because now you need to maintain oversight and due diligence. You also want to always select carefully if you have chosen a single provider, very carefully because of the financial stability issues, investment performance issues. Moving on to the fix-it slide now. I'm sorry, Marcia, my thoughts leapt ahead of the slide. If there are problems, any problems, the earlier you want to consider a change or make a change, potentially the better off you are. You can both add providers, continue to deselect providers, and on the next slide, let's kind of look at that. What's involved if you need to fix something that was wrong, and perhaps it's a provider that couldn't or was unable or unwilling to cooperate with you, and you're going to eliminate a provider. Just be sure to communicate those changes, not only to the other product providers so that they know who the approved providers are in your plan, and that's important to limit exchanges only to those providers, but communicate it to all of your employees. And always remember to change your list of providers for any deletion or addition, because remember that in the appendix to your written plan, you are supposed to have your approved providers listed. So change your list. It's not necessary to amend the document if you used an appendix. Always include on that list addition dates or ending dates just for your own records. And finally, remember that any provider eliminated after 1109, the accounts receiving contributions after 1109 is still a part of your plan, and compliance responsibilities still apply to those accounts. Having said all of that, here is my email address. If any of you, because of the speed with which I went through this, have questions, concerns, confidential, mind you, you are very welcome to email elouder@gainbroadband.com, and I will gladly, to the best of my ability, answer your question very objectively, by the way. Now, I would like to turn this back over to Donna.
Okay, thank you so much, Ellie, for the good information, and Beth and Marcia, too. And Leo, if you'll please remind our audience how to ask questions.
Ladies and gentlemen, at this time we'll conduct the question and answer session. If you would like to ask a question, please press 7# on your phone now, and you'll be placed in the queue in the order received. Please listen for your name or location to be announced, and be prepared to ask your question when prompted. You may also continue to send chat questions using the chat window to the right of the viewer. We are now ready to begin.
Okay, thank you. And we do have 2 questions that came in for Beth and one for Ellie so far, and keep them coming. Beth, we have a question from Suzanne Start, and her question is, so in other words, if someone asks me for the age 29 coverage, I have to offer it now, not at our open enrollment next July 2010.
This is actually a very good question, and it's very tricky because you have to make it available. So what that means, as a carrier, we have to offer it because of the law. So the member would have to call us directly.
So it's not going to be during the open enrollment time. It's any time, but they call you. They're not going to call the school district?
Correct.
Okay.
They don't have to make it available until their renewal date or any modifications. So it's not really an onus to them yet.
Mm-hmm.
However, we have to, because of the law, make it available to the individual.
Okay.
Which operationally, we still have to determine how we're going to view the individual back to the plan. Because as the law states, we have to offer the same coverage that the employee is receiving.
Okay, thank you. Now we have another question from Mary Gibson, and it's also for you, Beth. It says, is a consortium of schools participating in an experience-rated self-funded group exempt or required to conform to this mandate?
I guess I first want to ask what school district it is. Is it a true self-funded program, or is it premium credit or minimum premium?
I don't have that information right here.
Okay. Then I will go ahead and answer in two ways. Self-funded arrangement is not required to add it. However, most of the co-ops that Blue Cross insures are a fully insured program on a cost claim basis. So they're liable for their claims, and it looks like self-funded, but it's actually a fully insured product, and they are liable to add that upon the renewal or any modifications. And this is how it's going to be added is what I spoke about, and I think that's going to be some board decisions that come through at that level who will determine, do we add a rider, but we don't have a rate yet, a rider to extend the coverage, and everybody pays for it on the group, whether they add a child or 3 children under the law to dependent to 29, or do we just allow it as an availability at a full cost of a single premium? So those are the decisions.
Okay, now Mary Gibson did come back and say that she's with the Pittsford Central School District, and they are part of the Rochester Area School Health Plan.
And I believe they're a cost plus group.
Okay.
So they are mandated to add the rider. How they choose to do that is going to be a decision.
Okay.
Okay.
Okay. Ellie, we have a question here from Shelley Matisse, and she says, can amendments be made to our written 403B plan document at any time?
Thank you. Shelley, it's important to note that between now and December 31, 2009, in the eyes of the IRS, you need not have adopted your written plan yet. So between now and December 31, 2009, it is quite simple to amend your document. What I would do is simply ask your document provider, whoever provided that document to you, to explain the amendment that you want, and ask them to give you the new wording for your plan document. So it's really not an issue. Now, after January 1, 2010, it's going to depend, Shelley, on whether you folks, at some point the IRS is going to start approving plan documents, and you're going to have vendors coming to you with prototype documents. Once you use a prototype document, which probably is a pretty good idea since the IRS blesses the terms of those documents, you will have to officially amend it. And generally, you do that. There's usually a deadline for that, which is usually the end of the calendar year.
Okay, thank you. Now, each of you have a question again. And Beth Gillette from the Greece School District says, how will we know how that's being managed? She's talking about the health coverage from the prior question. And how will we be notified their school participates in a health consortium as well?
And that's some of, let me just clarify that, with the school districts, we are still working through logistics operationally to determine how that individual will be shown on the coverage, and that is coming through our membership, so it will most likely be showing on your bill.
Okay. And now, Nicole Gantz has a question for Ellie, and she said, effective opportunity question. We notify new employees in writing that they can make 403B contributions and give them our approved vendor list. We allow current employees to make changes at any time throughout the year. And here's the however. Beyond that, we don't remind people we have the plan. Do we still need to remind current employees of the availability of the plan throughout the year, every year?
That's a very good question, Unfortunately, the answer is much more simple than hopefully it's the answer you would like to hear. In fact, you are required under the regulations to provide an effective opportunity and a meaningful notice no less than once a year. Now, dividing that into two portions, you are perfectly okay to do an annual notice with the list of the vendors and enough good information so your employees can effectively use it, right? That can be done once a year. Now we get to effective opportunity. This is where the IRS is not as clear. In order to provide effective opportunity, the frequency with which you make changes looks good. The fact that you let them make changes or enroll at any time during the year is wonderful. That's certainly effective opportunity. So in my humble opinion, you can continue exactly what you're doing and be perfectly okay.
Okay, thank you. Now, Suzanne Start has another question about the age 29 coverage. She wants to know what number can she call or have interested employees contact?
They will call customer service if they're an Excelis person, or call their own health insurance carrier. So a member coming into the area, your membership area where people ask questions, they should be referred to our customer service. And there's also information out on our website.
Okay, thank you.
Yep.
And we have a live question.
Okay.
Okay.
First question comes from Martha with Smithtown Central School District.
Hi, Martha.
Hi, how are you?
Terrific.
Just wondering, the criteria for the extended benefits 29 states not insured. Would this include a person being insured under the Healthy New York programs, or is it an an employee-based insurance?
Nope. If they are offered any other insurance, including Medicare or Medicaid, they would not be eligible.
So that would be someone who would be enrolled in Healthy New York would not be eligible for the age 29 extension?
Correct.
But that's basically why they're taking part in the Healthy New York, is because it's not can't get them in on that, huh?
Correct. And the thing is, depending on how it is viewed, whether a group chooses to add it as a rider or whether they pay an individual rate, it may be lower cost for them to be on the Healthy New York program.
Okay.
All right, thank you.
Thank you. Anything else? I thought it was very interesting, Ellie, to know about this, the NTSAA Resolution Summit. And certainly anytime forms can be standardized, it's a huge
we honestly do believe, ladies and gentlemen, that this is going to make life easier for you, and that's the purpose, and also easier for your employees, because in these trying times, in these economic times, I don't have to tell you in terms of your own lives and school district budgets how difficult things are. Well, we all know it's also difficult for your employees. And when they need a transaction, whether it be an exchange because their investment choice isn't performing very well and they have a terrible need to get out of it, or whether it's a hardship withdrawal or a loan. Sometimes those are very urgent issues, and by standardizing and coming out with some really good best practices materials, we honestly think life will be easier. And stay alert, because ASBO, I'm working closely with ASBO on this too. As we get the results from the task forces, we'll start publishing them, so you'll be very much aware of them.
Oh, good. Thank you. Okay. Marcia, anything that you would like to end with? We only have a few minutes yet. But,
no, my biggest thing is just to thank everybody who participated in this, and then also thank the presenters for joining us today for this presentation.
Okay, and Beth, any final words about the age 29 coverage or Cobra?
The best thing is to check our website. As I said, there may be more to come. There's a lot of unanswered questions. Our department has been working through our lawyers who have submitted numerous questions, and we know that we cannot be the only carrier out there with questions of these magnitudes. So operationally, there's a lot of work to be done, but a lot of questions that are unanswered at this point. So stay tuned. Do look for your notices come the first week of October. And additional information, check our website, and you can call into our customer service that has Q&As available to walk through.
Okay, thank you. And Ellie, thank you so much for sharing your time.
Just to reiterate just one final point, because I know we're at the end of the conference. Number one, I want to thank Donna and Marcia. I was very impressed with my fellow presenters, and I thank Marcia for her insights in working with me. And I just want you to know that email address, you can feel very comfortable posing additional questions, and I will hold them in confidence and give you forthright answers. So thank you, everyone.
Thank you. And look forward to all of you participating in the September 30 webinar on ARRA and school construction funds. And always remember, we have the monthly planner webinar coming up in October, on October 15, and we also have a technology seminar or course that's opening on October 1st. So lots happening here at New York State ASBO. Thank you to everyone, and have a good afternoon.
Thank you.
This concludes today's webinar. Thank you for attending.
The moderator has ended the conference. Goodbye. Thank you for calling.